Well, hello, everyone, and welcome to Uncivil Law. And for today's story, perhaps unsurprising news, our friend Karen Reed has appealed to the U.S. Supreme Court relating to her double jeopardy issue. She is not leaving anything on the table. You got to give her that much. She is pursuing every end, no matter what. She has absolutely no chance whatsoever of getting the Supreme Court to pick up this case. I don't think she has any chance of getting Justice Jackson, who is the circuit justice, to issue a stay. There is no chance in this world. But she's trying anyway, and I guess you got to respect that. We turn our attention to the United States Court of Appeals, or apologize, not the United States Court of Appeals, a different court, the Supreme Court of the United States even. In the case of Karen Reed versus Norfolk County and Andrea Campbell and her official position as the Attorney General on a writ of cert to the United States Court of Appeals for the First Circuit. She is trying, man. She is trying. The questions presented: whether a final unanimous but unannounced decision by a jury following a trial that the prosecution failed to prove a defendant guilty of charge offense constitutes an acquittal, precluding retrial, and whether a defendant who produces credible evidence of such a final unanimous and unannounced acquittal is entitled to a post-trial hearing to substantiate the fact of this acquittal. Okay, she has absolutely no chance whatsoever of this working on any level, even a little bit, at all. There are none of the markers that are present for a Supreme Court case. There are none of the markers. There isn't any circuit split. This case isn't particularly extraordinary. It isn't of special national importance. It isn't of special weight that counsels a result. It's not, it's none of the things for which the Supreme Court would take the case. But I guess it doesn't hurt if you ask or something. Yeah. And we cite our tables of authorities. Okay. What would make a case so egregious? Think bigger. Think bigger, right? What would make a case so egregious the Supreme Court would get involved? Cases of massive national importance, cases of, fundamental, things that like shake the Constitution, separation of powers, think bigger. Think a lot bigger. Yeah. Statement of jurisdiction. The judgment of the First Circuit was entered. This court has jurisdiction. They sure do. Double jeopardy clause. This case is an ideal vehicle. No, it's not. To resolve an issue of fundamental constitutional importance, argued the court, but not decided in Bluford. No. The petitioner in Bluford argued that where a jury actually resolved some elements of a charged offense in the defendant's favor, no formal verdict needed to be returned for a decision to constitute an acquittal prohibiting re-prosecution under the double jeopardy clause. Would scandalous be necessarily bigger? No. No, you're not thinking big enough. It's the Supreme Court of the United States. Okay? National importance. Fundamental importance. Cases that, challenge fundamental separations of powers. Urgent questions that can garner no delay, that threaten the fabric of the country. That kind of thing. You're not thinking big enough. Think bigger. Constitutional rights? No. Think even bigger than that. Think bigger. Fundamental structural constitutional elements. Fundamental things that threaten the underpinnings of the Constitution itself. Think bigger. Think much bigger. Where a jury actually resolved some elements of a charged offense in the defendant's favor, no formal verdict need to be returned for that decision to constitute an acquittal prohibiting re-prosecution under the double jeopardy clause. Divide court did not decide that question because in Bluford, majority concluded that the four persons mid-deliberation report regarding that jury vote lacks finality necessary to amount to an acquittal, quite apart from any requirement that a formal verdict be returned or judgment entered. The instant case squarely presents the question that Bluford did not decide. No. Here, beginning the day after petitioner's first trial ended in mistrial, 4 jurors contacted trial counsel to inform them that the jury had reached a final and unanimous but unannounced conclusion that petitioner Karen Reed is not guilty of murder in the second degree and leaving the scene of a collision 2 of the 3 charges against her. A statement by the 5th juror relayed indirectly to counsel via 2 intermediaries indicates the jury had agreed that Reed is not guilty in the murder charge. In addition, one of the jurors made a similar representation to the prosecutor. The jury's not guilty verdicts were not announced because the trial court believing but not confirming the impasse reported a series of 3 jury notes, and this also implies, incidentally, that the court is required to accept partial verdicts, which is still not decided, incidentally. There is no case that says this. So this case doesn't work because it relies on the premise that the court is required to accept partial verdicts. And there's no case that says that either. So as a matter of the federal law, there's no case that says that. So if the jury had in fact stood up and said not guilty on counts 1 and 3, but we don't know as to 2, as to the federal law, there is no federal law that requires the court to accept partial verdicts. So the court could have just been like, not good enough. I'm not accepting any of these verdicts as a result of federal law, and sent the whole thing back for another trial. There's no federal law that requires partial verdicts. So this whole thing is like, oh, this is a verdict. Well, even if it was a verdict as to 1 and 3, even if it was, it's a partial verdict. And unless the court's required to accept partial verdicts, which there's no law that says they are, the whole thing is resting on a bad premise anyway. Doesn't every case have to have a first case? Sure, but the Supreme Court doesn't pick those up initially. The Supreme Court picks up circuit splits. That's typically the way that the Supreme Court gets to things. They pick up circuit splits. They allow the circuits below to come to various decisions, and sometimes when the circuits split, they sometimes pick up the case, but not necessarily even then. Sometimes they wait for more decisions by more circuits. So sometimes they wait for not just one circuit split, but they wait for like 2 or 3. But that's the typical way they get involved. If they're going to pick up a case other than that, if they're going to pick up a case that doesn't have a circuit split, you're looking for a case that has, again, like unique national importance, a massive question that needs immediate resolution, and so forth and so on. The Supreme Court doesn't do trivial. They're the Supreme Court. They only take cases that have nationwide impact. They are not there to solve one person's problems. That's not what they do with their time. TikTok and Garland didn't have a split. TikTok versus Garland was different because TikTok versus Garland was different because the case initiated in the Court of Appeals. The case started at the Court of Appeals. And so arguably under the relevant law, the Supreme Court was the Court of Appeals. So the Supreme Court sometimes is the Court of Appeals, and sometimes you have a right of appeal. You have a right of appeal from any 3-judge district court. Now, the Court of Appeals for the DC Circuit is not a district court, but it was acting as a district court because it was the lowest level of court. So there was actually a question in TikTok versus Garland about whether the Supreme Court had to hear the case or not. Because some people thought, including me, they had to hear the case because they were the Court of Appeals. So TikTok versus Garland was different because it started life at the Court of Appeals because the law said it did. So it was a different posture. This case has national significance? No, it doesn't. No. Yeah, this case does not have national significance. No, it is. No. We're not talking about a fight between the branches. We're not talking about something that undermines the Constitution itself. We're not talking about a constitutional crisis. No, this case doesn't have national importance. No, it's a routine murder case. There's nothing special about it. High profile does not mean nationally significant. No, it doesn't mean any of those things. You guys do understand that I'm considered a bit of an expert on the Supreme Court, by the way, by members of LawTube. I'm generally considered to be the most well-informed on the Supreme Court among my peers. Most of the people in LawTube think I'm the best when it comes to the Supreme Court. So I'm just saying, most of my peers recognize me as being the most well-informed. So when I tell you something about the Supreme Court, I'm generally considered the best. So when I tell you, no, this is not a case of national importance, I'm just saying that my peers generally recognize me as being pretty competent in this domain. Okay. Just saying. All right, where were we? Okay. Okay, we read this part, and so humble too. I'm just telling you my peers recognize me as being particularly competent in this domain. I'm just telling you that a lot of people recognize me as being the best. That's one of my areas of expertise. I mean, The First Circuit held that even if we assume the jury unanimously voted in private, the prosecution has failed to prove its case on counts 1 and 3. The jury did not act on that view. And accordingly, there's no act here that could be considered a ruling or characterized as an acquittal. That ruling runs contrary to the court's repeat emphasis over more than a century that what constitutes an acquittal for the purposes of double jeopardy is controlled by substance, not by form. That's mostly true. It's better than when others say it. Well, I'm just saying what others said. That ruling runs contrary to the court's repeat emphasis over more than a century that what constitutes an acquittal for the purpose of double jeopardy is called substance by form. What is your question, Dragonfly? So will they say yes or no? They're going to say no. There's no chance in this world. There's no chance in this world. It doesn't have any of the markers of this. They're not going to take it. They're going to deny it out of hand. Not a chance. Yeah. Plus, if the Supreme Court were to take it, they'd have to basically do everything in a rushed fashion, which the Supreme Court doesn't really like to do that either. So no. How much does it cost to file this? Oh, I forget. The most expensive part is actually the printing. Because the Supreme Court, the most expensive part of it is actually just literally the paper, because they use a special size of paper and it's a pain in the ass. But the actual cost of the appeal, just the raw cost of filing, probably $8,000 to $10,000 just for filing, not alone the attorney's fees. So yeah, $8,000 and $10,000 in actual costs, and then the attorney's fees, and it goes up dramatically from there. Particularly because they had to do it in a rushed fashion. It probably was very expensive. I mean, I could try to figure out a number off the top of my head, but we're probably talking, I don't know, $25,000 or something maybe in attorney's fees, given the rushed nature of this, because it was so fast. It sounds plausible. So let's say $30,000 to $40,000 for filing this, if I had to guess. It costs more than $8,000 in printing fees. Yeah. I mean, if you want to do it right, it does. It's printed on this special paper, and it's very expensive. And if you use one of the major companies, it's incredibly expensive. Yeah, it's a pain in the ass because the Supreme Court wants it printed on this paper size that no one else uses. It's 5 1/4 by 8 1/3 and some bullshit that no one uses. So you have to get it specially printed. And, they have to get it printed in these books and bound and blah, blah, blah. And, you probably don't want to go for the cheapest option. So, yeah, and also in this particular case, it's even worse than that because they're getting it printed in a rush. Because they're getting it printed so fast. They're getting it printed in a rush. So, yeah, $10,000 sounds like a pretty realistic estimate to my mind for the printing costs. The printing costs are brutal, man. I've never argued in front of the Supreme Court, never claimed to have argued in front of the Supreme Court. So no. It would be an honor to do so, but I've never argued in front of the Supreme Court. That holding runs contrary to the court's repeated emphasis or more essentially that what constitutes acquittal is controlled by substance, not form. The First Circuit's related denial of post-verdict voir dire further prevented Reed from providing all 12 jurors with what many of them without contradiction from other jurors was representing. That they reached a final unanimous unconstitutional decision to find her not guilty of murder. All right, so statement of the case, we kind of know what happened, so I'm going to skip the statement of the case because we read that kind of a lot of different times before. Okay, we read this. Yeah, no. Yeah, $10,000 is a very realistic estimate for the printing costs. Yeah, there are companies that specialize in it. Like you can do it yourself and stuff like that, but there are companies that specialize it and double check your work and or at least check your citations and things like that. So, you know, if you want to get it done to make sure it gets done right, you know, yeah. What's their filing strategy? Who knows? I don't know what their strategy is. Wrapping up costs. Can I give a logical reason why our team would be filing this? Not really. I don't know why they'd be filing this. Doesn't make any sense to me. She's made of money. They just want to rack up the bills. I don't know. It's wild to me as a business owner, the judge can restrict your speech if they fall within the business zone. Well, they're not trying to restrict your business speech. They're trying to restrict speech relating to this thing, time, place, manner restriction. You happen to be within the place of the buffer zone, so it's a time, place, manner restriction. So that's constitutional, intermediate scrutiny. And the judges tried to narrowly tailor it down. Yeah, that's going to remain in place. Is this breaking news? It's relatively breaking news. It was filed about an hour ago. Or news came to it about an hour ago. The Commonwealth filed a post-trial notice of disclosure to the court on Sunday, July 21st. Received an unsolicited voicemail on his phone. We can skip that. We raised the concerns in court. We can skip that. Decision below. We know what the courts below said. All right, reasons why this court should be granted. This First Circuit ruling conflicts with this court's double jeopardy case law. No, it doesn't. Including its consistent emphasis on substance over form and determining what constitutes acquittal. You're dreaming. As this court recently reaffirmed, the ancient right to a jury trial is no mere procedural formality, but rather a fundamental reservation of power to the American people. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct. Prominent among reasons the colonists cited in Declaration of Independence. Okay. Yeah, we know we're off to a bad start, right? You guys know we're off to a bad start. You know, this is the same problem that we had basically with the petition for the writ of habeas in the first place, right? The same problem we had. Like a lot of the citations are, America is great. America is wonderful. America is an awesome country with a rich, proud history by noble colonists and founders who loved America. Isn't America awesome? Yeah, when you're starting off with these really generalized platitudinal kind of statements, you're not having a good time, man. You're not having a good time. Yeah. Yeah. Someone said they worked for a FedEx office, can confirm they have to print an insane number of copies. Yeah, I forget what the number of copies is. It's like 42 copies or something. It's ridiculous. And then have them bound. Even normal appeals to local courts cost 2 to 3. Yeah, and then of course it's harder than that because the Supreme Court uses a special paper that absolutely no one uses. They have a special paper size just for them. They want to be difficult or something. So the special paper makes it challenging. The special paper is a pain in the ass. You know, there's a reason, by the way, that it looks like this on the page. I'll show you the page. You want to know what? That's why it looks like this on the page. You want to know why the margins are so big? You want to know why the margins are so big? Yeah, the margins are so big because the PDF is 8.5 by 11. But that's not how it's actually printed. So the margins are this big because the paper size is much smaller. And so it's printed on the 8.5 in the same size it would be in the booklet. So that's one of the reasons you know that, right? That's why the margins are so big, because this isn't the right size paper. Right? So that's one of the ways you know. So they can write in them. I don't know why the Supreme Court has the special paper. I don't know what they're doing. I don't know why they do things the way they do. They're the Supreme Court. They're things that are mysteries to me. I don't know. They do what they do, man. I just know the rules and we just follow it. What bureaucracy? Yeah, the Supreme Court has rules. If you don't like it, I guess you could appeal. After securing their independence, the founding generation sought to ensure what happened before it would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. How fast will they reply? Pretty fast. Pretty fast. They're going to discuss it on their next conference, and I would be amazed if they don't deny it immediately. They're going to deny it in their next conference, which is probably like on Tuesday or something. So probably Tuesday afternoon. The jury's overriding responsibility to stand between the accused and potential arbitrary or abusive government that's the command of criminal sanction. One of the central benefits of a right to trial before an impartial jury is that the jury acquits, the sovereign cannot re-prosecute. The double jeopardy clause. Yeah, it's like, again, just kind of this very generalized analysis. What controls an acquittal is not to be controlled by form. Rather, the court must determine whether the action actually represents some resolution. Here, affidavits by Attorney Jackson and Unetti reflect post-trial statements by 4 deliberating jurors. The jury had reached a final unanimous conclusion that they're not guilty on counts 1 and 3. And again, this implies partial verdicts are required as a matter of federal constitutional law, which they're not. At least no case says that I'm aware of. Yeah. They complicate intentionally. Well, once again, if you don't like it, feel free to appeal the Supreme Court's rules. Just so you know, I'm just telling you. Counts 1 and 3. A call by one juror to the prosecutor himself corroborated the trustworthiness of these representations. Yeah, trustworthiness is not the issue. Both the trial court and Supreme Judicial Court, for purposes of ruling on double jeopardy, proceed from the assumption that affidavits were accurate. Neither the Commonwealth nor respondent ever challenged the authenticity or accuracy of the statements. There was nothing tentative about the statements. To the contrary, they were definitive in describing the role of jury deliberations. The writ for cert will be denied. The Supreme Court will not take the case. The Supreme Court will not hear this case. The writ for certiorari will be denied. The Supreme Court will not hear it. There was nothing tentative about the juror statements. To the contrary, they were definitive in describing the result of the deliberations. Despite significant publicity that accompanied the filing of these defense motions, relying on jury petition, can you express how much weight the clerks have? The clerks have a lot of weight. There's a cert pool that most of the justices use because they get so many petitions. Also remember, by the way, of course, the Supreme Court only hears about 0.7% of all the cases they're asked, right? So that's the other thing, right? When they're asked, they only say yes about 1 out of every 140 times, give or take. And so, like, no is by far and away the most common answer. But yeah, the clerks, most of the judges use a cert pool, and they share their clerks. And then I'm not exactly sure how it works after that point, but yeah, basically the clerks basically decide whether to recommend it or not. And basically only if the clerks recommend it do the justices really take a look at it as a general proposition. Will they even look at the filing? Their clerks will. But will the Supreme Court justices look at it? Probably not. They have other things to do with their time. Do parties ever try to sway the clerks? No. No, absolutely not. That'd be 100% improper. Do they ever try to? No, absolutely not. No. The First Circuit rejection of Reed's claim on acquittal is rooted in formalism that's been consistently rejected by its court in a string of precedent. This emphasis on substance over form applies in the context of both jury acquittals and judicial acquittals. I mean, that's true. This court has, for example, consistently refused to rule that jeopardy for an offense constitutes an acquittal, where an acquittal is expressed or implied by conviction or lesser included. Yeah, but that's implied by something else. The acquittal here was the jury's unanimous and final decision reflected in post-trial affidavits that Reed is not guilty. This court has instructed that an acquittal has occurred if the fact finder acted on its view that the prosecution has failed to prove its case. It's not dispositive whether fact finder incanted the word acquit. Justice Sotomayor, joined by Justices Ginsburg and Kagan and Dissent Bluford, reaffirmed that asserting whether acquittals occurred, form is not to be exalted over substance. Rather, the court asked whether the fact finders made a substantive determination the prosecution has failed to carry its burden. Jeopardy terminates upon a determination, however characterized, the evidence is insufficient to prove a defendant's factual guilt. Reed cited two occasions in which a jury's unrecorded vote for acquittal was given effect, notwithstanding jury's failure to affirm the verdict. Yeah, okay, but in this case, they were correcting the record. It was a correction, so that doesn't apply. And this same seems to be true. So none of those things. The response is expected on May 5th. Yeah, well, yeah. That's about right in normal practice. So, yeah. The Bluford majority opinion is not to the contrary. I mean, it's not to the contrary, but it also doesn't help you. There, the four-person report against during deliberations jury was unanimously against the charge of capital murder in first degree, but split on lesser included. The court sent the jury back to continue deliberation when the jury remained unable to reach a verdict, declared a mistrial. The court rejected defendant's argument that double jeopardy clause prohibited reprosecution for capital and first degree murder. In doing so, the court relied heavily upon the lack of finality. National importance immigration cases Trump's fighting. Yeah, so like that, because that's a bigger issue, right? That's a case that's more likely to get some sort of attention by the Supreme Court because it's a case that involves potentially lots of people. It's a case that perhaps has some urgency to it, right? So Trump, with respect to the immigration stuff that he's doing, much more likely to get action by the Supreme Court because it's not just about one person, it's about a whole bunch of people and potentially being deported and potentially unredressable injury and so forth and so on. Yes, the court is going to deny this. Absolutely going to deny this. Did SCOTUS say they would hear this? No. Or is this just to the First Circuit justice? I don't know whether or not they filed a request for an injunction. I'm sure they did, but this is to the entire court. You know, the First Circuit erred in finding Bluford dispositive here. Unlike the four-person statements in Bluford, the affidavits reflecting juror statements in the case were all executed post-trial. The fact in this context, the affidavits do not so much as hint the decision to acquit was non-final or revisited any time is a powerful indicator of finality. We can't do FULD versus PLO right now, maybe tomorrow. That's going to take some time, and we don't have energy for that tonight. The jury's references to result of deliberations and not guilty verdicts reinforces the conclusion. Yeah. In these circumstances, the First Circuit's conclusion that even the Reed jury voted unanimously in private, the prosecution failed to prove counts 1 and 3. There would still be no acquittal. Well, I think that's probably true because, again, this all seems to rest on the premise that partial verdicts are required. So if the jury had come back and said, not guilty on 1 and 3, as a matter of federal law, the judge couldn't say, not good enough. I'm not accepting those verdicts. Partial verdicts are required. I don't know of any case that says that. So, yeah, and that would be a much more interesting case, though. That'd be a much more interesting case, but I'm not even aware of any case at the circuit level that says that partial verdicts are required. So, the Supreme Court probably wouldn't even take that case up, to be quite honest, because there's still not a split or anything else that would make it happen. Could this create precedents that judges must poll the jury? Well, anything the Supreme Court does would create precedents, but they're not going to do anything, so it's not going to create precedents. And the precedent that does exist in the First Circuit right now, because the First Circuit rendered an opinion, the precedent that the First Circuit has goes the other way. The court doesn't deny a writ, they just choose not to hear. That's the same thing. Denial of the writ is the refusal to hear. That's the same thing. The writ of cert is the request. So the denial is the refusal. Is it the end of the road? Yes. Is there a reason they file this? No. Do you think they know they'll be denied? They'd be foolish not to know it'd be denied. The First Circuit also repeatedly affirmed district court's conclusion that even assuming a post-trial voir dire elicited evidence strongly favorable petitioner, such as attestation from each jury, the jury voted unanimously to acquit on count 1 and 3 before being discharged, the claim still failed. Yes. Under that reasoning, sworn and credible statements by all 12 attesting to final unanimous decision would not be sufficient. Correct. That result is not required by logic or precedent and is inconsistent with the court's precedent. No, I'm not sure it is. Additionally, the First Circuit cited concerns about maintaining the secrecy of the jury deliberations in denying the request. In the analogous context of juror bias, it's not analogous because that's corruption of the process by the jury itself. It's not analogous. The law is clear that the defendant's Sixth Amendment right to an impartial jury also guarantees the opportunity to prove a claim of bias. But no one's claiming the jury is biased, so it's not equivalent. Post-verdict inquiry is similarly required to investigate claims of external influence, but there is no external influence. Reed submits that there is no legal basis or constitutional basis to afford less rights to a defendant seeking the ultimate benefit of a right to a jury trial and acquittals found by a unanimous juror than those regularly granted defense raising process-related challenges. There really, really is. There exceptionally is. Because in both cases, the problem is that the jury itself was not a fair jury. Right? Either the jury was influenced externally, they were bribed, they were threatened, or they were not a fair jury because of biases, because of race, for example, or some other pollution of the process. So yeah, the problem was you're entitled to a jury, and you're entitled to a fair jury, but there's no one's claiming this jury wasn't fair. That's not the claim. Not the claim of the air things. By the way, do you like my solo cup on my display behind me? I thought it was appropriate to add the solo cup to the rotation. Red solo cup, I fill you up with tears, tears of sadness, tears of denial. I should have a harem where they all lay around pillow talk style while you talk law to us. That would be an interesting harem. That would be an interesting harem. Yeah, that'd be an interesting version of pillow talk. Hey, baby. Miranda. Ooh, say it again. Am I doing Lori Vallow on Monday? No. Will there be White Claws? I don't really like White Claw because I don't like malt liquor, but I will have a vodka-based one. Probably High Noon is more the one I tend to go for. Malt liquor-based ones make me sick. So no White Claw, but vodka-based ones, we can roll that way. I have standards. A good faith Fifth Amendment double jeopardy claim where Reed has met or burn a production should be entitled to no less procedural protection as good faith claims of jury bias. Reed acknowledges there are little precedent involving factually simulated situations here. Yeah, that's not really helpful. The lack of precedence is a problem. This case is unique. This is also like death. This is death at the Supreme Court. This case is unique. This case is unique. Oh, that's like a death sentence right there, man. Just give up hope, man. It's not often that after trial, one juror, much less four jurors, directly contact defense counsel, stating in no uncertain terms the jury had acquitted. But the unique strength of the evidence underlying Reed's motion to dismiss clearly demonstrates she has met her burden of production and fully supports rather than undermines her claims of relief. If the Supreme Court grants this, I mean, I might just have to give up the game. If they grant this, I don't. Yeah, just this one time. Yeah, exactly. So, man. Ordering a post-trial voir dire would answer the First Circuit's concern that not guilty determinations were not final. In fact, this court is held in federal habeas court must grant an evidentiary hearing, whereas here, the merits of the factual dispute were not resolved in the state hearing. If this gets to oral arguments, can we get Lally to argue for the Commonwealth? Well, no, it would almost certainly be the Solicitor General of Massachusetts, I would imagine. But if Karen Reed needs lawyers to argue this for her at the Supreme Court, well, she already has some. But if she needs other lawyers, I'm available. I'll be happy to be the sacrificial lamb and get my teeth absolutely handed to me. But I'll do it. I'll do it as I get destroyed. This is a necessary corollary of the straightforward proposition. The First Circuit was also wrong to deny the request for post-trial hearing to maintain confidentiality. The results of the jury deliberations are not secret. Yeah, but there's no way we're going to be able to do this in one question. There are, in fact, routinely announced in open court. Yeah, the inquiry requested by Reed could be accomplished by a single or at most small. Did you notice that change? That's nice, right? Because they used to be able to say, we could do this in a single question. They're hedging their bets, right? In the previous filings, they said we could do this in a single question. They're hedging their bets. Now it's a small number. What exactly is a small number? Unclear. Of yes, no questions posed by a jury, did you unanimously acquit Karen Reed the charges in count 1 and 3? Or similar questions? If all 12 jurors answered those questions affirmatively, no speculation regarding the basis for a unanimous conclusion could alter significance. What if one of the jurors doesn't, incidentally? What if one of the jurors says no? That's not true. Are you seriously going to have no follow-up questions relating to that? Right? What if we did this, and what if 11 members of the jury come and say, yes, we're unanimous, and one says no? Are you going to ask the judge to make a credibility determination? That the 11 said yes and the one is lying? Are you how's that going to work? You know? Prior to the enactment of Federal Rule of Evidence 606, which the parties agreed was facially inapplicable here, so we're going to discuss something that doesn't matter for a while. The court held that the rule against jurors impeaching their verdicts applied only in proceedings actually impeaching the verdict, which indisputably does not describe the case in which they're attempting to prove the jury reached a verdict. And the court has held, at least in some circumstances, inquiries required even where it violates Rule 606. Well, I mean, yes, as a constitutional matter, if she's constitutionally entitled, then sure, the rule has to bend to the Constitution. In some defense learned post-trial, the jury reached a verdict that was not announced. I need to start taking bets on whether the defense is going to ask for partial verdicts at the end of this case. We need to start a betting market. Will the defense actually ask for partial verdicts at the end of this case? Because you know they're going to be asked, right? When they're doing the jury question, when they're doing the instructions for the jury, you know they're going to be asked. Will the defense actually say, yes, we want partial verdicts? Are they actually going to do it? I don't think they are. I don't think they're going to do it. We should start taking bets. Would I? I don't know, man. Do we even have the charges? Yes. Yes, the same charges as before. I thought partial verdicts weren't accepted regardless of whether they're asked for. They are accepted under Massachusetts state rules. The Massachusetts state rules allow for the inquiry of partial verdicts, and if they're asked for, then the judge is required to enter them. So it's possible under the state level rules, yeah. But whether or not they'll do it, who knows? In some defense learned post-trial that jury reached a verdict that was not announced. It was at least entitled to the opportunity to substantiate that fact in order to ensure Reed is not unconstitutionally forced to stand trial for criminal offenses, including murder, of which she's already been acquitted. Such an inquiry in no way intrudes on the deliberative process of the jury. Such an inquiry instead honors jury service, we're going back to the platitudes, which the trial court described as extraordinary, rather than rendering irrelevant the efforts of at least 4 jurors to disclose they were not in an impasse. Reed contends the double jeopardy clause guaranteeing against successive prosecutions is no less fundamental than the Sixth Amendment right to an impartial jury, and no less concluding. Well, that's the end of the petition, and then there's just a whole bunch of appendices. So at least they kept it short, and then they just have a lot of appendices for a while. So, yeah, no, none of those things. None of those things. So I'll take questions. What about just wanting everyone to be treated fairly? That's not what the Supreme Court does either. The Supreme Court doesn't say let's treat people fairly. That's not what they do. The Supreme Court interprets the law. That's their job. They interpret the Constitution. Fairness is equal application of the law. That's what fairness is. Can Karen Reed follow suit? No. Regardless of whether she's found guilty? No. And even if she's found not guilty, she can't sue. She has no basis to sue. Yeah, she has no basis to sue. None that I'm aware of. And certainly not if she's found guilty. And it costs $10K for a piece of paper for them to read it? Yeah, about that. That's correct. After writ is denied, there's a 25-day appeal period, which needs extraordinary circumstances. Yeah, no, it's not going to happen. Yeah, the court is not going to grant this. Absolutely no chance. No chance in this world. Yeah, none of the markers are there. There's no circuit split. It's not extraordinary. It's not a case of a unique national importance. It's not a case that, demands some sort of immediate review. It's none of those things. It's none of those things. Who is she supposed to sue? She can't sue anybody. She has no cause of action. Karen Reed has no cause of action against anybody. She has no valid cause of action. The paper thing sounds dumb. Be that as it may, it's the rule. It just is. She can't sue Proctor? No. Can she sue under 42 USC 1983? No. First of all, her constitutional rights haven't been violated. Second of all, even if they have, there's not been clearly established. She'd fail on element 2 just like everyone else. She can't possibly get past clearly established. Not a chance. Yeah, she has no cause of action under 1983. Do I think she's guilty? No. No, I don't think the evidence allows for a conclusion of guilt. I've watched the first trial. I think the evidence is shit. I think the evidence is absolutely shit. I'm surprised continuously that the state is continuing to prosecute this case because the case is in evidentiary shambles. And it's only gotten worse since then because Proctor's been kicked out of the force and everything else. So it continues to surprise me. But yeah. Partial verdicts usually favor the defense. I don't know if that's true. I think partial verdicts might favor the prosecution, to be honest. I assume there's been studies on it done, but I assume they favor the prosecution would be my assumption. If the evidence is so bad, why do I think the prosecution is continuing? To save face? I don't know. Their ethics aren't very good? I don't know. I appreciate you guys spending some time with me, by the way. Yeah, I'm sorry I can't give you better news on some of this stuff. Like I said in Melanie's chat earlier, like, what did I say? I said, oh yeah, I said, for example, the lawsuit by the people trying to get the buffer zone to go away, that's going to fail. And I said, what else did I say today that their chat wasn't happy with me was saying? I forget, but yeah, I said something else, and one of their mods accused me of like stirring up drama. I'm like, I'm not stirring up drama. I just don't think it's going to work. You know, I don't think they're going to succeed. You know, so yeah. What's with the no caps warning in chat? I don't like all caps. It's that simple. It bothers me. So the no caps warning is there because if you type in all caps, your message will be automatically deleted. So it's there to prevent you from doing that. It's a rule. Are Big Larry's that scary to mods? It's distracting. I find it visually distracting. So I don't like it because it bothers me visually. It's that simple. What do I think about the juror lawyer lady? I think it's the most awesome thing I have. I'm definitely standing Victoria. I am standing Victoria hard. The fact that the former juror has joined the defense team, I think is the most hilarious thing I've ever heard of in my life. I think it's great. I hope she does. I hope she gets to question at least one witness, maybe a more minor witness. I know she's not a criminal lawyer by training, but she'll be fine. Maybe we can find a minor witness for her to cross-examine or for her to question. I hope Victoria gets to participate in a substantive way. That would make my day. Amidst the buffer zone discussion, can you summarize what would fail? There were other high-profile cases that never had buffer zones. Well, whether or not they had buffer zones and whether or not they could have buffer zones are two different questions. Now, it's of course important to note that in the Depp case, that was a civil case. So that raises slightly different concerns because there are more constitutional protections for a defendant in a criminal case. So first of all, there's that. Second of all, like, could there have been a buffer zone in the Depp case? Sure, probably, right? The fact that the judge didn't do it for whatever reason they didn't do it, is their own call. But just because they didn't doesn't mean that they can't. And basically, it boils down to a time, place, manner restriction, right? We're concerned about them being there in this place because we're concerned about people getting in and out of the courthouse. We're concerned about ingress and egress. We're concerned about the jurors. We're concerned about noise near the courtroom. We're concerned about these kinds of things. And like, these are all very reasonable concerns. And the prosecution had asked for 500 feet. And the judge was like, no, how about 200? And it's like, okay, I mean, that shows to me the judge is trying to tailor the buffer zone to the situation. It's like, it shows that she's trying to find basically to narrowly tailor the restriction to the potential issue, right? And so it's like, okay, I'm just going to have a 200-foot buffer zone. And also crowds, of course, can just be a bit dangerous, especially crowds that are, highly passionate. The fact that nothing has happened thus far is certainly no guarantee of that in the future. And so, like, for any combination of reasons, just to make things a little bit more, a little less powder keggy, maybe, it's like, okay, so it's, there's a substantial governmental interest and it's narrowly tailored to address that interest. And it's not based on the content of the speech. No one is allowed within the zone to protest or anything. And it's like, so, and to the extent that private and, don't use bullhorns, again, that's a manner restriction. Don't use sound amplification devices. That's manner. So that's fine. To the extent that businesses are using, sound amplification, it's something they would have been doing anyway, right? And so, and there's no reason to reach to that. There's no reason to reach to that because, like, they would be doing it anyway. So, if they're just doing what they would normally do anyway, then there's no concern. So it strikes me as, very well balanced and considered to try to deal with the risk or try to deal with the profile. It's like not 500 feet, 200 feet. And I'm concerned about the jurors and people getting in and out of the courtroom. And I'm concerned about noise. And I'm concerned about, the hubbub of it all and, so forth and so on. Seemed pretty plausible to me. Will it be my best strategy if I was representing Karen Reed? Just focusing on weaknesses in the state's case. Just being like, just focusing on the doubts. I'd be focusing on all the doubts based on reason. I just list out all the doubts and I just spend all my time dealing with that. Would be all my doubts. Yeah. I hope Karen Reed gets acquitted. I still can't believe that 8 members of the jury were ready to convict on some version of manslaughter. That doesn't make any sense, right? This is the thing that's continuously frustrating. 8 members of the jury last time were ready to convict on some version of manslaughter. How? How? Karen Reed was there. John O'Keefe was there. Therefore, Karen Reed did it. Okay. I mean, whatever, right? I mean, come on. Apparently there's private property within the zone and she's ordered that they cannot wear clothing with it as part of the order. Well, clothing can be expressive. Clothing can be expressive. So to the extent that the clothing is expressive, then it is, again, tailored to deal with that expression. So no, I don't think the fact it reaches clothing changes the analysis. Because clothing can be expressive. And if it's meant to restrict the expressive speech, within the zone, then, seems like fair play. Wearing color pink is weird. I wear pink, has nothing to do with Karen. Yeah, well, you know, it is what it is. I suppose if, you were just coming in and out, and weren't trying to loiter there, then, it'd probably be fine. I don't think they're going to go out of their way to try to exclude everyone who's wearing pink. I don't think they're going to, I think they're going to try to like make a basis that makes sense. What's the deal with pink colored clothing regarding Karen Reed? I assume it's no more complicated than Karen Reed is a girl, therefore pink, which seems kind of sexist, but it wasn't my call. Cops are threatening people if they walk through the zone too many times. Yeah, that makes sense. That makes sense because if you're just coming to and going through, right, then, if you're just if you're just going through the zone for the purposes of going to a business, you go to the business and then you leave, right? So if you walk through the zone too many times, it sort of reflects that your purpose is something else. So that makes sense, right? It all makes sense to me. Pink is her favorite color? Well, pink is my favorite crown. Pink are also the sheets I lay on. What's the topic? Karen Reed went to the Supreme Court as the topic. What's my legal forte? Supreme Court is basically my best legal forte. Yeah, this is where I live. U.S. Supreme Court is my jam, man. That is my jam. Can they restrict hairstyle if it's expressive? Yeah, I suppose. In principle. In principle, if there was this particular hairstyle that indicated something, then maybe, yeah. That's possible, I suppose. Will they find her guilty or not guilty? As to my prediction in the new trial, I don't know. My prediction in the new trial is going to be based on the evidence that's provided at the trial. So I have no idea. I'm unable to offer any sort of meaningful prediction as to the new trial because we haven't heard any evidence as to the new trial. So there is some possibility that somehow the prosecution is going to fix some of its problems, and there's a possibility that the defense will fall asleep at the switch, which would obviously change the odds. So there's some possibility that the odds of conviction will go up relative to last trial, based on what is actually offered in the case. So until we actually start seeing the case being presented, I can't possibly offer an opinion as to what I think will happen in this case. If the state somehow manages to figure out a way to fix their problems and the defense, disappears on us, then, that will change the odds substantially. So I can't really say until we get there. What specifically elevated me to be a Supreme Court subspecialist? What elevate? First of all, I don't think elevated is exactly the right term. I don't think it's necessarily an issue being elevated. As to what makes me a specialist, reading a lot of Supreme Court cases is what makes me a specialist. Reading a lot of Supreme Court cases. I read like all of them, like every year, and a lot of historical. Basically swimming in these waters is what makes me a specialist. In the Supreme Court, just reading the cases is what makes me a specialist. That's the answer. That's kind of what makes you a specialist in any area of law, to be honest. It's just by reading. And the more you read, the more specialist you are. That's kind of the answer. Reading a lot. Annabelle Feinstein, $5. Thank you. Am I still practicing law? I'm licensed. I don't really practice, but I'm licensed. Sometimes I do some minor consulting work, but not really. I'm licensed in Virginia, Texas, and before the Supreme Court, but I don't really practice very much. Although last year I did write a brief for somebody, which was very fun. I enjoyed doing that. I'd like to do a Supreme Court brief again. Leslie and Jackson will keep it spicy? Probably. If I was representing, would I feel agitated or demotivated by Bev's treatment? Probably demotivated. But these guys seem to be pretty good about, not getting demotivated. Yeah. Yeah. Can I only write a brief for the states I'm licensed in? No. I can write a brief for anyone. I'm licensed before the Supreme Court. So I can write a brief for anyone out of any state or territory or country, theoretically, because I'm licensed. So I can write a brief for anybody for the Supreme Court. The one I worked on was out of Illinois. So, yeah, no problem. Did I clerk? No, I didn't clerk. My opinion on the new lawyer? You mean Victoria? I like Victoria. I think she's going to be great. Have I done maritime law? No. No, maritime law is definitely its own little specialty. Have I ever seen a judge as biased as Bev? I'm sure I have. I'm not sure anything's come to mind. I've never argued before the U.S. Supreme Court. No. No, never had the chance. Do only people that want to be judges clerk? No, not necessarily. And you don't have to be a judge. You don't have to clerk to be a judge. It's not required. I think I might like to be a judge someday. I think I'd prefer to be an appellate judge rather than a trial judge, because I'm much more concerned with legal issues than, factual issues. So I think I much prefer to be an appellate judge. You'll vote for me? Thank you. I appreciate that. Take your case and you'll get to argue in front of the Supreme Court. Well, if you have a case that you think would be good for me, then send me an email. My email is listed in the video description. If you think there's a case in which I can help you out with the Supreme Court, let me know what the case is. Let me know, and provide me a copy of any judicial decisions relating to your case that exist. And if it's something that I think that I can help you with, we can talk about more specific terms. Do I know international law? Yeah, there isn't any. Yeah, there really isn't any international law. In the end, there really isn't any. So yes, I know international law because I know it doesn't exist. Yeah. Does state law trump federal law? Depends in the relevant domain. Yeah, it depends is the answer to that question. Federal law trumps, but only where federal law is valid. The federal power is much more limited than state power. So state power trumps most of the time is actually the technically correct answer. So most of the time, state law trumps because the federal power is very limited. The federal government is one of enumerated powers. It's one of limited powers. So, but the federal law is supreme, but only when the federal law is valid, and their domain is relatively minor in the grand scheme. The federal government has power principally internationally and principally as it relates between states, and then also principally as it relates to federal land. So if it's federal land, if it's between states, if it's international, it's probably federal. Otherwise, it's probably state level power. That's the most technically correct answer you're going to get on this question. If both state and fed regulate, then who's the final say? The question's too broadly asked. Depends. Depends. The question's too broad. If the federal government has preempted the field, then the federal government wins. If not, then the state government is likely to win. And so you're asking questions way too broad. Sounds like it's up to who argues better. It's not who ups. No, that's not right. It is not up to who argues better. That's not the right answer. It's a question of domain. It's a question of who has the power in what domain. It's not based on who argues better. It's a question based on the boundaries of power. Yeah. Have I read much on interstate commerce? A whole shit ton. I've read a lot on interstate commerce. Yeah. I've read a lot of interstate commerce classes. Yes. Reservations for natives? Yes, reservations for natives, also federal law. That's correct. Sorry, but Kurt is definitely not a constitutional expert. I definitely am. I 100% am a constitutional expert. Like guns, I guess would be good. Both Fed and state regulates guns. Can state pass gun laws that conflict with federal laws? That conflict with federal laws? No. You email me, consult on privacy law if you know about privacy laws. Do some. Boundaries and power sound subjective. It's not. It's not subjective. No. It cannot be constitutional. A judge's discretion can deny an accused of their constitutional right to be only tried once for one crime. You're correct. That is a true statement. It is in fact not constitutional for a judge's discretion to deny an accused of their constitutional right to only be tried once. You are in fact correct. Discretion cannot trump constitutional rights. That is 100% correct statement. It just doesn't mean what you think it means. But what you wrote was literally correct. Is qualified immunity unconstitutional? The Supreme Court doesn't say so, so no. They're the ones who invented it in the first place. Massachusetts versus Jones, a case allowing the state to compel an individual unlock their cell phone, computer, or encrypted file. Yeah, that depends a lot on issues. I don't want to get into that. Do I ever think they'll get rid of the Patriot Act? No. What else? Biggest loophole in the Constitution? I don't understand the question. There are no loopholes. There are only laws. Brother counsel talked about qualified immunity. If I want to learn about it, I'm well familiar about qualified immunity. I've talked about it many times on my channel. I am well familiar with qualified immunity. Do I think a different judge would have dismissed due to video footage? No, not for that reason. No, I don't think so. If a circuit court makes a decision, does it only become law in the states that circuit rules over? Yes. So each time a circuit rules, it only has binding authority on the states within its circuit. Correct. Which then means you have the potential of conflicts between circuits, which is one of the reasons the Supreme Court takes up cases sometimes. Is there juror selection tomorrow? Yes. Am I covering it? No, there's nothing to cover. According to the Constitution, should I need a driver's license to drive inside your state? Yes. Yes. The state is sovereign. The state has power. So the question would be whether or not there's any provision in the Constitution that would prohibit the state from doing that, and there's not. So therefore, rational basis review, and therefore, yes, the state can require a driver's license. It's easy. First Circuit is Maine, New Hampshire, Mass, Rhode Island, Connecticut, and Puerto Rico. You are correct. Thank you for remembering Puerto Rico. If I was writing a motion to the Supreme Court on Karen's behalf, what would I cite? You said think bigger. I can't do it. I can't do it. I can't do any better. She doesn't have it. She doesn't have anything for me to work with. She doesn't have the right posture. Her case is not big enough. Her case is just not big enough. I can't make it bigger. She just doesn't have it. There's nothing I could write that would be any better than what these people wrote. These people's writing is fantastic. There's nothing wrong with their writing. It just isn't enough. So is a driver's license required on a tribal reservation? I don't know the answer to that question. Tribal reservations are typically governed by tribal law. You'd have to ask the tribe, I think, would be my answer. Is she as good as screwed? Well, it depends what you mean by that. The Supreme Court's not going to grant the cert petition. Sovereign citizens are dumb. They're retarded. Sovereign citizens are functionally retarded. And I think we should lock them all up summarily. Yeah, that's what I think about this. I think the soft sits. That's what I think about soft sits. I think we should round them all up, and I think that we should lock them up. And they can't complain. They can't complain, remember, because the law doesn't apply to them. Remember? They're the ones who said the law didn't apply to them. So we can round them up, and we can put them in jail. And they said, what about due process? And I'd say, what about due process? You said it didn't apply to you, remember? You said you were sovereign, remember? You said that these laws didn't apply to you, remember? What due process? There isn't any. Please enjoy jail. That's what I think. That's what I think. Will I lock up their corporation and straw man? You bet your ass. I'll lock them up every possible which way. Lol. I always find it very funny that sovereign citizens try citing authority when they're in court. I always find that very hilarious. The sovereign citizens are like, we're sovereign. We're not subject to your law. Also, I'd like to talk to you about the UCC. Wait a second. Pick a lane. Pick a lane. You know what I mean? We need to beat more jails if Kirk gets power. We'll just get a nice island. We'll get a nice island. Maybe Guam. Maybe we can send, yeah, we'll just find a nice island somewhere. And we'll send all the sovereign citizens to the island and they can figure it out. They can have their own Lord of the Flies conch shell. I'm going to send them to the island and I will provide a conch shell, but only one. And then you guys can figure it out. Let me know how it turns out for you. We'll find an island somewhere. How about the North Marianas Islands? Maybe there's an island over there. Maybe we can find an unpopulated area island somewhere in the Middle Pacific. Is Alba available? Where they sent Napoleon, that little island off the coast of Africa, is that available? Can the United States buy Alba? Maybe we can send all the sovereign citizens there. That'd be good. We'll send them to that little tiny island off the coast of Africa. That sounds promising. I will personally spend money to send the sovereign citizens to an island. We will give you your sovereignty. You'll love it. Lol. We'll find somewhere. We'll find somewhere. It'll be fine. It'll be worth it. I don't care if the U.S. has to go into debt for this project. I'm willing to do this. I'm willing to. I'm willing to do this. The United States can spend $100 billion on buying whatever island this is and sending all the sovereigns there. That's worth it. We'll go into debt. I'm willing to contribute. I'm willing to contribute to the cause. Let's go. Yeah, no, Karen Reed can't sue anybody. She can't sue Canton. She can't sue anybody. She has no cause of action. Karen Reed can't sue anyone if she's found not guilty. She has no cause of action. All right, guys, I think I'm going to go ahead and sign off because I'm getting a little bit tired. It's 10 o'clock. I'm a little bit sleepy on civil time. I'm going to try to get some sleep. I think I'm going to see if I can knock myself out for many, many hours. Try to get some good hardcore sleep. So I'm going to sign off, but this has been fun as we've been hanging out. I'll check my email tomorrow. I'm way too tired to do it now, but I'll check it tomorrow. I'm Uncivil Law. Until later, my friends. I hope all is well for now. Cheers, my friends, for now, and goodbye.